Hello everyone. Hello everyone. Today, I hope everyone is okay and everyone is safe at their respective homes. This virus is actually, quite consuming. So stay safe and let's, utilize this time to learn something new, learn something adventurous, and learn something which will help us in our futures as well. So today we'll discuss basics of understanding criminal law procedure as to how it works in India. So, firstly, right now, criminal law procedure is governed by the Code of Criminal Procedure 1973. Prior to this, it was governed under the British Colonial Statute Book, that was the Code of Criminal Procedure 1898. After 1973, there were certain changes which were made. The earlier 1898 Code of Criminal Procedure was shrugged off, and since then, 1973 Code has been governing how procedural law in India works. Understanding criminal law would basically involve three things. Like law can be divided into three things. One is the substantive law, one is the procedural law, third is the adjective law. Substantive law in cases of criminal law, in criminal cases would be the IPC or other station and local statute books such as NDPS Act, such as PMLA, and other statute books. For example, there's a law in Maharashtra governing superstations. There's a law in MP governing, in Rajasthan governing anti-poaching, in other parts of India as well. There is section 6 in the Code of Criminal Procedure, which is the connecting nexus between the procedural law and the substantive law. Substantive law as such is something which defines what a crime would be, what would be the territories in which that particular act or omission would be treated as a crime, and what would be the punishment which the courts can award subsequently after the trial for committing such a crime. The procedural law governs as to how the investigation will happen, how search and seizure would happen, how trial would start, how prosecution would be done, and how evidence will be led. The third category is adjective law, that is the Indian Evidence Act 1872. That is again another British colonial statute book. It governs as to how evidence is led, what can be admissible in evidence, what is relevant for the purposes of evidence, and how a trial can be conducted. It applies also to civil cases, so that is why it is not strictly penal or strictly criminal in nature. It is per se an adjective law. We'll focus today on understanding as to how criminal law works, as to how procedural law and criminal law works. So the CRPC 1973 is a long statute book. It is written at a novel length and in a very lucid and interesting manner. So the first point of ignition where the criminal machinery kicks off is, reporting of a crime. But prior to that, we should also know what exactly would constitute a particular crime or allegations of commission of a crime, commission or omission or act of a crime. Now, the first thing which basically involves, which sets up the criminal machinery would be information of the particular crime. Now, this information can be of two types. One, either through an FIR, that is the first information report, or through a complaint made to the magistrate under either section 156 clause 3 or under section 190 other clause section 200. Now, if an FIR is registered, now FIR can be registered only in cases where there is a cognizable offense which has been committed. In cases where in cases where a cognizable offense is committed, that is something where FIR kicks in. In cases of non-cognizable cases, there is something which we call the NCR as non-cognizable report, which the police registers in form of an NCR. There is no FIR registered in non-cognizable cases because by virtue of section 155 clause 2, the police cannot investigate any non-cognizable offense. So the trigger of the machinery is either an FIR or a complaint. Now, a complaint can be made in three cases. One, where the police refuses to register an FIR and you go to higher authorities. The higher authorities also do not register an FIR. You go under 156 clause 3 to the magistrate and say that the police has refused to lodge my FIR, kindly instruct so. Another sort of complaint can be that a direct complaint is made to the magistrate, and the magistrate can either issue process or reject the complaint or direct any investigating agency or any other person and authorize him to conduct an investigation in that regard. Now, post FIR, the first thing which is to be done is that a copy is to be given to the complainant or the informant, and thereafter the police kicks off the investigation. Now, investigation would include collection of evidence, picketing, collection may include collection of DNA samples, may include a search and seizure of certain premises, certain seizure of vehicles, certain seizure of documents. It may also include of electronic devices, of other material, whatever police thinks is required for the conduction of investigation. The police may conduct investigation in their own. That is governed by the Police Manual and the Police Act and certain local laws as well, and certain notifications as such as well. Now, at this stage, there is one more important thing which we should know, that who should be or which should be the investigating agency which will conduct the investigation. Now, generally, the FIR is registered with the police of the concerned police station. In case someone is in a different jurisdiction and someone has to lodge an FIR immediately, what the police does is they lodge an FIR, which is in layman's parlance known as a zero FIR. So what they do is they take out a zero FIR and give a copy to it and then send it to the concerned police station under whose jurisdiction that particular commission of crime may have happened. Now, there are 2-3 things which we should know at this juncture. For example, if someone is traveling in a train and the purse is stolen, so where should the FIR be registered? The FIR may be registered at the station where the person thinks that my purse may have been stolen, or at any police station subsequent wherever the cause of action arose, because the train is a traveling in its traveling mode throughout where all places it goes. Now, coming to the investigating agencies again. Now, in case the state government thinks that the particular crime is of such nature that it should be conducted, that the investigation should be conducted by CBI or NIA or the concerned crime branch or any other agency, the state government may send it to the concerned agencies for conduction of investigation. At this point on, we should also know that the High Courts and the Supreme Court, they have certain powers to transfer the investigation from one agency to the other or from one state to the other. Transfer of investigation from one state to the other is done in very, very rare cases where the courts think that they have to issue a writ to this effect saying that investigation may not be properly conducted in a particular territory, so it may be transferred outside that particular territory for smooth conduction of investigation, because there may be cases where someone very influential is involved. So he or she may hamper the investigation in certain manner. Courts may also think that that a particular commission of crime is of such nature that it should be investigated by a dedicated team. For example, if it involves national security, it may transfer it to the NIA or to the ATS or to a particular or any other investigating agency as well. These investigating agencies, after conduction of investigation, submit their report through the local police which had registered the initial FIR. They may also, in case it is directly awarded to them, they can also directly file a challan or a charge sheet in the court or may drop the case as the case may be. Now, after conduction of investigation, the police has 3 options. One, they'll either file a challan or a charge sheet. During investigation, police also has certain powers to take custody of any accused against which they have certain evidence, or they want certain cooperation in the smooth conduction of the investigation. Now, this is something which we in general parlance called PC, police custody. Within 24 hours of such arrest or taking of custody, they have to submit the particular accused or the particular person before a magistrate, before the competent magistrate, wherever they have, wherever the police jurisdiction lies. And the magistrate may thereafter either award PC, which you call as the police custody, or JC, which we call as the judicial custody. Under judicial custody, the particular person is sent to the jail directly, and it will be counted for the purposes of, in case he is awarded punishment thereafter after the conduction of trial, that period will be counted as incarceration. Under police custody, they are directly given to the police to interrogate and the police may, as per law, dig out certain information or certain recoveries from that particular accused. Now, after conduction of investigation, the police either files a challan, which in see that is under section 173 clause 2 CRPC, that is called a police report. As such, the police report can be in form of a challan or a charge sheet saying that this particular person has committed this offense, or these particular persons have committed this offense, and there is ample evidence to this effect. There is a proper format in which charge sheet is to be filed. It will include name, place, other relevant documents which they have, other relevant information, relevant recoveries which they have recovered during the course of investigation. They have to submit everything to the court. Other option may be that after conduction of investigation, the police finds that, okay, against these 5 accused, we have found ample evidence and they should be tried, and then cognizance should be taken against them. Against these 3 people, we don't have sufficient evidence till now. So therefore, it may be transferred. Therefore, against these particular accused, we may be granted an opportunity to do further investigation. Also, the police may say that we have found against only one person, he has committed something which we know, but against other people, we don't have any information. So their case may be closed against them. So this person may be tried alone. Now, once the police submits the charge sheet or the challan against everyone, now subsequently the police may also file supplementary charge sheets against, for example, in the second case as we just discussed, the police files charge sheet against 3 persons and keeps it pending against 5 people. Against 2 of them, police finds ample evidence again and finds a supplementary charge sheet. That will be charge sheet, for example, the charge sheet is 1 of 2020, it will be 1A of 2020, and then supplementary will be 1B of 2020, 1C of 2020. In this fashion, they generally file the charge sheets. Thereafter, the magistrate before whom the challan is placed, now the magistrate in every jurisdiction, the magistrates have a fixed number of police stations which are tied up to that particular court. Now, the magistrate has 3 options again. The magistrate may receive the challan as it is and thereafter issue summons or take cognizance in general sense. The actual expression is taking of cognizance. It also may be known as issuing of summons. The police may take, the concerned magistrate may take cognizance of this case and issue summons to the accused against which challan has been filed. These accused will have to thereafter make themselves appear before the particular magistrate, and thereafter they will be tried. The magistrate may also refuse to accept the challan and say that you have done nothing, this investigation is shoddy and slipshod, and I will not accept it. You have to do further investigation and come to me again after doing a thorough investigation. The magistrate may also see if there are 5 accused, but there is evidence only against 4 of them. The magistrate may take cognizance against only those 4 and not take cognizance or not accept the final report made by the police against the 5th accused, and he may not be summoned at all. This lies in the discretion of the concerned magistrate. The third option may be that the magistrate, this is the third option thereafter. Now, if the magistrate thinks, if the case is particularly triable by a sessions court alone, then the magistrate will have to do something which is called a committal. The magistrate commits it to the sessions court, and thereafter sessions court will frame charges and issue the further procedure. If that is triable by a magistrate, the magistrate may take cognizance and issue summons. The accused, they'll have to make themselves appear before the magistrate and obtain bail. We'll discuss bail separately thereafter. And thereafter, the magistrate may issue process and issue trial and start the trial by putting the case for framing of charges. Now, this is a very important stage, that is framing of charges, that is under section 211 CRPC. Now, the magistrate will have to do something which we called a charge base or a charge hearing for the accused. The accused, once they appear, all accused, once they appear, they may be granted bail, taken into custody and granted bail by the concerned magistrate, or they may be sent to JC. In case the magistrate, and thereafter, in case once all the accused they make themselves appear before the court will thereafter put the case for framing of charges. Now, charges, for example, the police has filed, for example, the FIR was registered under 8 sections. The police finds evidence after investigation only under 5 of them, files charge sheet against 5 of them out of the 8 initial charges made in the FIR. The magistrate has complete discretion of framing charges of which he or she feels after hearing the accused. Because till now, this is a one-sided investigation which has been done. The accused, because the statement of accused is not even necessary in the 161, and it may not be have been, if, in case even if taken, it may not have been annexed with the charge sheet. The magistrate may not have the benefit of reading it. Also, at this stage, before framing of charges, there is something which is called Section 207 and 172A1 of CRPC. The accused has a right to have a copy, a legible copy of the charge sheet which has been filed against him, so as to prepare his defense. Now, after these formalities, that is all a small formality under Section 294 order. So, then the magistrate hears the accused on framing of charges, and thereafter he frames either discharges the accused, saying that none of the 5 charges against him, under which he has been charge sheeted, can find place under the law, and this case has nothing. So therefore, I discharge them. This is generally under section 227, 228 before the Session Court, and the 238, 229 before the Magistrate Court, and the warrant trials upon trial. If they are discharged, the case ends there. In case the magistrate feels that they should not be discharged and they should be charged and the trial should be started, the magistrate will frame charges, and the magistrate has to frame all charges separately against all accused, and thereafter they'll have an opportunity. Thereafter it will be put for prosecution evidence. Now, the prosecution evidence, because the case has to be opened by the prosecution, because in India, the burden of proof lies on the prosecution to prove a particular case beyond reasonable doubt. Not even doubt, beyond reasonable doubt, it has to be proved. So the burden of proof is on the prosecution to say that these accused have committed a particular crime. So the prosecution opens the case and prosecution evidence is being led. Along with the charge sheet, there is a list of witnesses which is supplanted to the magistrate. In this list of witnesses, there will be around, depends on from case to case, the IO will be a witness, there will be other persons whose evidence would have been taken. Now, once the prosecution evidence starts, the public prosecutor conducts or lays down the evidence of a particular accused after oath, and thereafter the accused have different, if there are, for example, if there are 5 accused, all of them have a right to cross-examine that particular prosecution witness on his particular testimony. In case someone dies before being cross-examined, his evidence is not read into at all. Also, at this stage, the public prosecutor has to get exhibits marked for each witness who comes. For example, the doctor's evidence. For example, if there is a murder case and there are stab wounds, and the post-mortem report, the doctor has opined that these may be knives by a particular knife of a length of 10 centimeters. Then the doctor has to prove his evidence or the post-mortem report, which will be thereafter exhibited before the court, and thereafter he'll be cross-examined on it. Once the prosecution evidence is closed, and in case the defense wants to examine someone, for example, the defense pleads alibi that I was not present at the spot of commission of crime, they'll have to prove some documents. For example, if he was traveling, he'll produce an air ticket or a railway ticket or a bus ticket. If he was staying in a particular hotel, he'll have to submit those documents and prove it to the court. If he wants testimony of someone, for example, hotel's manager or the bus driver or a co-passenger from the bus, he'll have to get his evidence thereafter. But defense evidence is led not in almost all cases, but in very few cases, because the burden of proof is on the prosecution to prove their case. Once this is complete, thereafter something which is known as the final hearing takes place. The prosecution opens final hearing, And if the magistrate is not satisfied with the prosecution's case, it can end the case there and acquit the accused. So there's this difference between discharge and acquittal, because discharge happens at the stage of framing of charges. Acquittal happens after the conduction of trial. Now, if the court feels that, okay, prosecution has said something which may be there and thereafter I'll have to hear the defense side, the court will hear the defense. And in case the court finds that, okay, prosecution has been able to prove their case beyond reasonable doubt that these particular accused only conducted this particular crime, thereafter, the magistrate or the concerned court will convict those particular accused. He may convict few of them and acquit few of them. He may convict all of them or acquit all of them thereafter as well. Once conviction is complete, the case is put up for hearing on sentence. For example, if there is a murder case and the court finds three accused guilty under 302, then thereafter it is put for sentence hearing, that is under section 235 clause 2 CRPC. And on the after sentence hearing, the magistrate will pronounce the sentence. After conviction, the accused, if they were on bail, their bail bonds are seized and their sureties are cancelled and they are sent to judicial custody, and thereafter they are produced by the police thereafter for the sentence hearing. After sentencing, the trial is over because they are not completely sentenced. They'll have to surrender before the court if they have not yet surrendered, and thereafter they have to, in case they want to appeal, they'll appeal. This is generally the procedure as to trial, as to how trial is conducted. Now thereafter, after trial comes appeals. Now appeals can be generally of two types, that is appeals against acquittal and appeals against conviction. Generally, appeals against acquittal can be made by the complainant in the case the complainant is not satisfied. Earlier, the complainant or the informant or the victim, they had to obtain leave from the court. Now it is not necessary. Or by the state, because all criminal cases are against this, by the state against the accused. Appeals against conviction would be again of two types. One would be by the accused who have been convicted. Other may be against by the complainant or by the state for enhancement of sentence. For example, in a particular case where the maximum sentence is life imprisonment and someone has been awarded with 7 years, then the state may appeal that this case, that the sentencing is not proportionate to the crime, and this sentence may be enhanced to the maximum or to 10 years or to any other particular sentence provided by the law under the code, under the concerned substantive law. Now appeals, this section 386, that this will be under section 372 or 374 or 378 CRPC. The powers of an appellate court are under 386, and a very important power lies under section 391. Before we delve into appeals, there are a few ancillary provisions which we should know. There's something, and a very interesting provision in law, that is section 319 of the CRPC. Now, section 319 CRPC says that after initiation of the trial, at any stage, if the magistrate feels that another person has to be summoned as an accused at any stage before the judgment is pronounced, under section 319, or either on its own or on an application made by the PP or by the complainant, under section 319, the court can summon an additional accused to the court and ask him to subject himself to trial as well. There's a very landmark judgment of the Supreme Court, that is Hardeep Singh's judgment. It says that the powers under section 319 CRPC can be they have to be exercised sparingly. They'll be exercised only on the basis of evidence produced or which has come before the court during trial, not on the basis of the charge sheet. This is very important for section 319 CRPC. Also, at this stage, we should discuss about the bail jurisprudence, that is section 436, 436 capital A, 437, 438, and 439 of the CRPC. And apart from, and there are other ancillary provisions in different statute books as well. Thereafter, now the bail is generally at two stages. In case someone has been nabbed by the police and he's produced before the concerned magistrate before the 24, if during the 24 hours period, he'll apply for bail, that is regular bail again, under section 437 CRPC. In case the court commits him to either PC or JC, he'll have to apply for bail under section 439 CRPC. There's something which is called bail in anticipation of arrest, or what is popularly known as anticipatory bail, that is under section 438 CRPC. Now, anticipatory bail says that if someone, not necessarily an accused, if someone has a reasonable apprehension of being arrested by the police, he can go to either the sessions court or to the high court directly and say that I may be arrested in this particular crime or this particular FIR. I have an apprehension that I'll be nabbed, and I have no connection with this crime at all. Therefore, and there are other 10 guidelines in one is Gurbakshin Sibi and other Siddharth Mitra, saying that I am not connected with this crime at all, and I should be given bail in anticipation of an arrest. So the direction, in case anticipatory bail is granted, the direction is to the arresting officer or to the investigating officer of that particular case, which we known as who is known as the IO, saying that in case he is arrested or taken into custody, he should be released on bail for such and such amount as the IU may decide, or as for a surety of such and such. This is anticipatory bail. In cases of regular bail where JC is taken or PC is taken, that is under section 439, there are 6 parameters in general which a court takes into consideration for granting of bail: nature of crime, nature of fact, there are chances of hampering of the evidence, chance of recovery, and other factor: age, if there's someone is sick, someone is a woman, depends on a lot of factors. Now thereafter, another interesting provision in CRPC, section 482 CRPC. Now section 482 CRPC is inherent powers of the High Court to do complete justice or to prevent abuse of process of the law. Now at every stage, that is one, if cognizance is taken, or if FIR is lodged, or the charge sheet is filed, or charges are framed, at every stage the accused can approach the High Court under section 482 CRPC for quashing of the FIR, or quashing of the charge sheet, or dropping of certain charges, or quashing of the summoning order, or quashing of the charges which are framed against a particular accused. The state may also approach the High Court under section 482, but that is done in very rare cases. Then under section 482, the High Court has very sweeping powers, very highly discretionary but judicially guided powers to quash FIR. For example, if a false FIR registered against someone where a particular accused is not at all connected with a particular crime and has been nabbed by either by police deliberately or through influential people in the society, the High Court has sweeping powers to quash such FIRs and to quash further proceedings emanating from such FIRs as well. But there's something, and this is also interesting again, revisionary powers. So in criminal law, unlike civil law, there is no review as such. Civil law permits review of particular orders or interim orders as well. Criminal law, there is no review by virtue of section 362 of the code. In criminal law, there is either an appeal or a revision. A revision does not lie against an interim order, and a revision lies only where an appeal is not provided for. For example, you don't file a revision petition against a conviction in the first place. It has to go as an appeal, and thereafter it may get converted into a criminal revision. It depends on case-to-case basis. But there is no revision against an interim order. Wherever an appeal is not provided, for example, if someone wishes to challenge an order framing charges against him or her, a revision would lie by the magistrate. A revision would lie before the Sessions Court, that is under section 397, 399, 401 CRPC. It depends either to the High Court or the Sessions Court, wherever the jurisdiction lies. So this is also important. For example, and this is important, why? Because framing of charges is a final order in a sense, because this order attains finality the moment that order is being passed, and it is not amenable to be revised by that particular court alone. It has to be revised by a superior or higher court. Other ancillary provisions are, for example, Section 391 of CRPC. 391 CRPC deals with additional evidence which could be let at the appellate stage. Now, the burden of proof is on the one who is submitting that particular evidence as to how and why he or she could not produce that evidence even after due diligence before the particular court or something. So there's some new discovery of fact, new discovery of evidence, some change in interpretation of law, or this evidence was not available at that particular time. That can be led into evidence by virtue of Section 391 of the Code of Criminal Procedure. Also, other interesting topic is a difference between a fresh investigation, a proper investigation, and a further investigation. Now, once a charge sheet is being filed against an accused or a group of accused, the magistrate takes cognizance of the same and orders cognizance or directs further investigation in the matter because the investigation then may not be proper. The magistrate also, by virtue of Sakiri Vasu's judgment, has ample powers to order fresh investigation. For example, if the court is not satisfied with the investigation at all and says that, okay, what you have done is completely incorrect, then we say that, okay, you go ahead and do the investigation afresh because this investigation is shoddy and cannot be, a trial cannot be started on the basis of this. Proper investigation also is a term used in by the magistrates, and that is interchangeable term. Is one more thing which requires which attracts attention here. That is something which a jurisprudence which the Supreme Court has lately developed. That is of the court-monitored investigations. In the 2G case, in the Hawala case, that Vineet Narayan's judgment, that is a continuing mandamus issued by the Supreme Court. That in particular cases where a large number of accused are involved or accused are highly influential, the court may say that, okay, we'll dedicate this investigation to someone or to a particular agency, but we will monitor it. That is something which is called the court monitored investigation. That is also permissible in law. So the Supreme Court or a High Court may direct investigation and then monitor the same as well. And thereafter the entire trial will follow suit. Now, once an appeal is being heard and decided, at the appellate stage, the court may, by virtue of Section 386 of the court, the appellate court has ample powers to alter the order, to modify the order, to uphold the order, to reverse the order, or to remand back the matter as well. There's a very famous that based bakery judgment by the Supreme Court, Zahira Sheikh, in which the Supreme Court ordered a retrial after trial was done by the trial court and the appeal was also over. Thereafter, the Supreme Court ordered that, okay, no, this is completely incorrect, so we'll order a retrial. That is something which also lies within the power of an appellate court. Now, once the High Court also importantly in cases where death sentence is given by the Sessions Court, the High Court, there has to be a confirmation by the High Court. It goes on Section 366, 369 of the CRPC. And those, in case they're cross appeals, they may be clubbed and heard together. The confirmation may also be heard together by the, with the appeal by the accused. Now, after a judgment, after the appeal is being heard and decided by the High Court, there are only two ways to the accused or to the state. That is to approach the Supreme Court through either an SLP or through a criminal appeal. A criminal appeal lies only in two cases. One, where the High Court itself conducted the trial. That is a power of the High Court under Section 474 CRPC. The High Court may say that no one else will conduct a trial. This is an important matter. High Court will itself conduct a trial. Where the High Court conducts the trial, so there's a right to appeal because first appeal is the right to every citizen. First appeal lies to the Supreme Court. Or in cases where death sentence is given, then a right to appeal goes to the Supreme Court and has to be heard by minimum 3 judges of the Supreme Court. other cases may be where the trial court acquitted, but the High Court convicted and sentenced for death sentence or life imprisonment. There also a right to appeal lies to the Supreme Court. In all other cases, there is an SLP criminal which is to be filed and which goes to the Supreme Court directly. Thereafter, once the Supreme Court also upholds the sentence, thereafter, also importantly, there is something, an ancillary provision, that is section 389 CRPC, that is suspension of sentence. Now, if the trial court, after conduction of trial, sentences someone for only or for less than 3 years of punishment, then the sentence stands automatically suspended if someone files an appeal within a particular period. The sentence gets suspended, and during the pendency of the appeal, the accused may not be committed to the jail, because otherwise the appeal may become infructuous if someone is not able to, if the appellate court is not able to complete the hearing of the appeal within the particular assigned period. In more than that, if the punishment is more than 3 years, an application is filed along with the appeal, that is under section 389 of the code. Now the accused will say that, okay, I've been adjudicated as a convict and sentenced to this effect. This conviction and subsequent sentence is not proper, and I may be heard I've been sentenced to 7 years. I've already served 2 years or 1 year or 3 days or 1 month, whatever. That I have a very strong case before the appellate court because I have been wrongly adjudicated as guilty. And in case my sentence is not suspended, then by the time the hearing of the appeal gets over, because due to the pendency, then my appeal will become infructuous. Therefore, by virtue of section 389, I should be granted, my sentence should be suspended for during the pendency of the appeal. This, and one must note the difference between suspension of sentence and suspension of conviction. Now, sentence is something which flows from the conviction. Sentence can be suspended. Suspension of conviction is something which is very, very difficult. Generally, what happens is in cases relating to Prevention of Corruption Act, under where the ACB, Anti-Corruption Bureau, files the charge and conducts the trial, gets the trial conducted. Now, during pendency, if there is a public servant involved, the public servant may be suspended or terminated from his or her service. That particular department may terminate him. Now, suspension of, and in case he is found guilty. Now, if the appellate court suspends the sentence, that will not affect the departmental proceedings which have been taken against that particular accused or particular convict. In case the conviction itself is suspended by the appellate court, that will have an impact or have a bearing on the departmental proceedings, because the convict, he is no more a convict because the conviction stands suspended, not alone the sentence, because sentence is something which flows from the conviction. Now, thereafter, there are few other small provisions, that is with small applications which are filed during the trial, that is under section 91. In case someone wants to bring something on record which is not in his or her possession, that is under section 91 for calling of the documents. Section 125 CRPC, that is the maintenance section, which goes to the family court now under the Family Courts Act now. There are other small sections relating to arrest, relating to powers of courts, relating to powers of the investigating officer, relating to the powers of any private person who can make a particular arrest. It also lays down the timeline for from 6 a.m. to 6 p.m. for arrest of a woman. There are certain definitions which are important: definitions of victim, definitions of warrant case, summons case, investigation, inquiry, cognizable, non-cognizable, bailable, non-bailable. The CRPC has a schedule which carries who all are cognizable, non-cognizable, bailable, non-bailable. There's another important concept, that is compounding of offences, that is in the section 320 and 321 of the code. Section 320 has two types of lists or which are compoundable in nature. There are few offences which are compoundable between the accused and the informant. For example, there is a case of a very small brawl, like I pushed someone, I get pushed by someone. Now these cases may be compounded between the parties, and they can be settled, because there is no point that a complete trial is conducted in such small cases. Now, there are few cases which cannot be compounded without the leave of the court. They are particularly more where the sentence involved is more. So, permission of the court is to be taken. There's an application filed before the court, and the court may allow compounding of such offences or may decline that such offences cannot be compounded. If the state wishes to do so, the PP has to file an application to that effect as well, and the accused should be heard. Now, for non-compoundable offences, offences which are not mentioned in section 320, the court has no power to compound it. That is under section 320 clause 9 of the CRPC. Now, there's something which, now there are a few cases, for example, Gyan Singh's case, that whether the High Court under 482, section 482, can quash a non-compoundable offence on the basis of settlement between the parties. The judgments subsequent to Gyan Singh also, and Gyan Singh also says so in para 61 or para 52, I guess, that any offence which has bearing on economic, political, social tones, or where the sentence, where the offence is grave, they cannot be settled, or they cannot be quashed on the grounds of settlement between the parties. The reason being that in case there's someone who is influential, or someone who has certain power or influence over the informant, may say that okay, there can be cases where someone puts someone to a threat and asks them to sign a particular affidavit of withdrawal of the case, of settlement of the case, or someone may offer money, or someone may start doing this as a matter of practice to get a case filed and then take settlement money and then get it settled before the High Court. Therefore, this particularly in non-compoundable cases, this rider has been given by the Supreme Court, that the High Court has power to do so, quash even the non-compoundable offences, but not in every case. In very rare and exceptional cases, it can do so. So the criminal procedure in India is, it has been written in a very lucid manner. It involves certain technicalities, yes, but otherwise it is simple to understand and simple to decode. I'll be very happy to take questions. If someone wants to ask any questions, they can write to me. They can email it to either to Think India or to me directly to office@namitsaxena.in. Thank you for hearing me. Thank you so much. All